Hello and welcome to LiveLaw Daily. I'm your host Debujit Das. Today, August 4th, marks the birth anniversary of Sir Firoz Shah Mehta, one of the founding members of the Indian National Congress and a towering figure in India's early constitutional and political history. As we look back at the legacy of one of country's foremost legal minds, let's turn to today's developments from courts across India. Our first story deals with a fresh challenge in the Supreme Court over who should lead India's central armed police forces and whether Parliament can overturn a Supreme Court judgment through a new law. The court today issued notice to the Union government on a petition filed by 34 CAPF officers challenging the constitutional validity of the Central Armed Police Forces General Administration Act of 2026. To understand the dispute, we have to go back to a Supreme Court judgment delivered last year. In the Sanjay Prakash case, the court had directed that the deputation of IPS officers to senior posts in the Central Armed Police Forces should be progressively reduced. It had also held that Central Armed Police Forces should be treated as organized Group A services, giving their own officers greater opportunities for promotion. But Parliament later passed the 2026 CAPF Act, which allows the central government to continue filling a large number of senior CAPF posts through IPS deputation. The law also says that it will operate notwithstanding any judgment or order of any court. So the petitioners argue that this amounts to an unconstitutional legislative override. According to them, Parliament cannot simply nullify a Supreme Court judgment without removing the legal basis on which that judgment was delivered. They say that the new law violates the principles of equality, equal opportunity in public employment, and the separation of powers under the Constitution. A bench of Justice Manoj Mishra and Justice Vijay Bishnoi has now sought the Union government's response, and the constitutional challenge will be taken up in the coming weeks. Our second story deals with a significant order from the Supreme Court on how women will be represented in state bar councils across the country. The court has now clarified who can be nominated as the two co-opted women members in every state bar council. Instead of leaving that decision to the bar councils themselves, the bench said that the nominations will be made by the Chief Justice of the concerned High Court. A bench of Chief Justice of India Suryakant, Justice Joy Malia Bagchi, and Justice V. Mohana said that the two women members should be chosen either from among former women High Court judges or senior women advocates with a good standing at the bar. According to the court, this would bring greater objectivity, independence, and transparency to the functioning of state bar councils. And the court also clarified that even a woman candidate who unsuccessfully contested the bar council elections can still be considered for co-option. During the hearing, another issue also came up. Several senior advocates questioned the Bar Council of India's recent move to increase the number of seats in the state bar councils after the court introduced 30% reservation for women. Chief Justice of India Suryakant observed that when the court ordered women's representation, it never intended to increase the statutory strength of the councils. He also remarked that if the number of seats is increased in future, women's representation would have to increase proportionately. The larger question on the election process, including the system of transferable votes, have now been referred to the Justice Sudhanshu Dhulia Committee, which will consider suggestions from members of the bar before making its recommendations. Our third story deals with fresh contempt proceedings involving AAP leaders, arising not from the Delhi excise policy case itself, but from what they allegedly said about a judge during those proceedings. In February of this year, the trial court discharged all 23 accused in the excise policy case, including Arvind Kejriwal, Manish Sisodia, and BRS leader K. Kavita, while making sharp observations against the CBI's investigation. The case had already drawn national attention, with Kejriwal spending 156 days in custody and Sisodia 530 days before both secured bail from the Supreme Court. Now the matter has taken a different turn, however. Kejriwal, Sisodia, Saurabh Bharadwaj and several other AAP leaders appeared before the Delhi High Court today in contempt proceedings linked to social media posts made during the recusal controversy involving Justice Sharma. The petition says that after Justice Sharma refused to recuse herself from hearing the CBI's challenge to the discharge order, several videos and social media posts were published targeting the judge. She subsequently initiated suo motu contempt proceedings and transferred the matter to another bench. Today's hearing also included a separate contempt petition filed by Ashok Chaitanya, who has sought action against Kejriwal, Bharadwaj, AAP leader Gopal Rai, and journalist Saurav Das, alleging that they scandalized the court. The High Court has now allowed all the respondents to file their replies. It also directed the petitioners to place the material he is relying upon on record within a week, along with an affidavit. The matter will now proceed after the replies are filed over the next 4 weeks. Our fourth story deals with an unusual turn in Tamil Nadu politics, where the Madras High Court has stepped in just hours after the leader of the opposition, Udhayanidhi Stalin, was arrested. The case stems from a speech Udhayanidhi made at DMK rally in Thanjavur on August 3rd during protests over the Kaveri water sharing dispute. A complaint was later registered alleging that parts of his speech contained derogatory remarks against women. Based on that, the Thanjavur police booked him under several provisions of the Bharatiya Nyaya Sanhita, the IT Act, and the Tamil Nadu Prohibition of Harassment of Women Act. Udhayanidhi has already moved the Madras High Court seeking anticipatory bail. But before his petition could be heard, he was already taken into custody from his residence, prompting his lawyers to urgently mention the matter before the court. And when the case came up, Advocate General Vijay Narayan informed the judge that although Udhayanidhi had been arrested and was being taken to Thanjavur, the state did not intend to seek his judicial remand. According to the state, he only needed to be questioned and would then be released on station bail. Regarding that statement, the High Court directed the police to release Udhayanidhi on station bail after interrogation itself, while also directing him to cooperate with the investigation whenever required. The court therefore did not go into the merits of his anticipatory bail plea at this stage. Our fifth story deals with a long-running defamation case filed by some of Bollywood's biggest production houses, where the Delhi High Court has now given relief to Corp, the company that owns the social media platform X, or known as Twitter. The case goes back to 2020, when 38 film production houses and major Hindi film industry associations sued several television news channels, social media platforms, and others. They alleged that after the death of actor Sushant Singh Rajput, sections of the media had portrayed the entire Bollywood industry as being involved in drugs and criminal activity, causing serious damage to its reputation. During today's hearing, Corp argued that 6 years had passed, no interim takedown order had ever been passed against it, and much of the content referred to in the suit had already been deleted by users themselves. It therefore sought to be removed from the case, or at least be exempted from appearing in court. The plaintiffs opposed that request, saying that the suit is still pending and future takedown directions may still be sought. Justice Sachin Datta did not remove Corp from the case, however, observing that it remains a proper party since it may have to implement any future directions passed by the court. However, after Corp undertook to comply with all future court orders, the High Court exempted it from appearing in further proceedings unless specifically required. It also clarified that if the plaintiffs seek any specific relief against Corp later, the court will consider it in accordance with law. Our next story deals with two well-known public personalities approaching the Delhi High Court on the very same day, seeking protection of their personality rights. First, Bollywood actor Tabu moved the High Court, asking for protection against the unauthorized use of her name, image, and identity. When the matter came up before Justice Jyoti Singh, the court noticed that some of the defendants had not been properly identified in the case papers. So Tabu's counsel was asked to file a fresh memo of parties and listed the matter for hearing on August 6th. Tabu now joins a growing list of public figures, including Aishwarya Rai Bachchan, Abhishek Bachchan, Karan Johar, Nagarjuna, Sri Ravi Shankar, and journalist Sudhir Chaudhary, who have sought similar protection before the Delhi High Court. In another case, Physics Wallah founder Alakh Pandey has also sought protection of his personality rights. His counsel told the court that fake social media accounts were using Pandey's image, catchphrase "Hello Bachcho," AI-generated content, and other personality attributes to sell products, spread defamatory content, and circulate explicit content. But Justice Anup Jairam Bhambani observed that the lawsuit appeared to combine several different legal issues, including trademark infringement, copyright, defamation, and personality rights. The court asked Pandey to clearly classify the alleged violations and indicated that it may consider interim protection, particularly against those commercially exploiting his identity. The matter will now be heard further tomorrow. Our next story deals with the medical condition of Asaram, whose plea for suspension of sentence is currently being heard by the Supreme Court. The latest development is that AIIMS has submitted its medical report to the court. According to the report, Asaram does not require hospitalization, but he does need 24-hour assistance from trained caregivers because of multiple health conditions. These include coronary artery disease, osteoporosis, thalassemia, and recurring gastrointestinal problems involving blood loss. The report assumes importance because the Supreme Court had specifically directed this medical evaluation while considering Asaram's plea seeking suspension of his life sentence on health grounds. For some background, Asaram was convicted by a special POCSO court in Jodhpur in 2018 for raping a woman at his ashram. He was sentenced to imprisonment for the remainder of his natural life under provisions related to rape by a person in a position of trust, gang rape, criminal conspiracy, and the POCSO Act. His conviction was later upheld by the Rajasthan High Court, which he has now challenged before the Supreme Court. The matter came up today before a bench of Justice M.M. Sundaresh and Justice P.B. Varale. However, since Solicitor General Tushar Mehta was unavailable, the hearing has now been adjourned to Thursday, when the court is expected to consider the AIIMS report while hearing Asaram's plea. Our next story deals with a question that could affect who gets to contest local body elections in several states across India. The Supreme Court has reserved its judgment on a challenge to Maharashtra's law that bars people with more than 2 children from contesting panchayat and other local body elections. The case was filed by Mangala Bhimrao, a former sarpanch who was disqualified after the birth of her 3rd child under the Maharashtra Village Panchayat Act. Her disqualification was upheld by the Bombay High Court, after which she approached the Supreme Court. During the hearing, the bench of Justice P.S. Narasimha and Justice Alakh Aradhe once again questioned whether the Supreme Court's own 2003 judgment in Javed versus State of Haryana, which upheld similar 2-child norms, may now require reconsideration. Lawyers assisting the court placed data showing that there is no uniform policy across the country. According to the material submitted, 7 states have repealed such restrictions. 15 states never even adopted them, while states like Maharashtra, Gujarat, Assam, Goa, Odisha, and Uttarakhand continue to enforce the 2-child rule. The judges also noted that Javed's decision was decided by a 3-judge bench and said that they will now consider whether that ruling could be considered by the present bench or referred to a larger constitution bench. And with that, the court reserved its judgment, leaving open an important constitutional question on whether such electoral disqualifications continue to pass constitutional scrutiny. And our final story deals with an unusual development from the Rajasthan High Court, where a newspaper report has led the court to launch a public interest litigation on its own. The trigger was a Dainik Bhaskar report claiming that a large number of properties in Jodhpur, including judges' official residences, schools, colleges, temples, and several residential and commercial properties are recorded as Waqf properties in official records, even though the revenue records allegedly show otherwise. Taking suo motu cognizance, a bench of Justice Pushpendra Singh Bhati and Justice Praveer Bhatnagar observed that these claims raise serious questions about the accuracy of public records and the manner in which certain properties came to be entered in the Waqf Gazette and uploaded on the state's Ummeed portal. Pending further examination, the High Court has directed the state government to maintain status quo over all the disputed properties. That means there can be no transfer, mutation, lease, construction, demolition, or any other step that changes either their legal or physical status. The court has also asked Jodhpur District Collector to carry out a physical verification of the properties with photographs and GPS details, while directing the Rajasthan Board of Muslim Waqf to produce the complete records explaining how these properties came to be listed as Waqf assets. The matter will now be taken up again on August 11th. And that's all for today's edition of LiveLaw Daily. If you'd like to read any of these stories in full, you'll find the links to all our reports in the description box below. For the latest updates from the Supreme Court, the High Courts, and the rest of the legal world in India, keep visiting livelaw.in. We'll see you tomorrow.